10 years ago, the Supreme Court issued its decision in Shelby County versus Holder. The case took aim at the Federal Voting Rights Act, which protected and expanded the freedom to vote for Black Americans and voters of color who historically faced intentional barriers to voting. The court struck down the act's pre-clearance formula, which had required states with a history of racial discrimination at the ballot box to get permission from the Justice Department before enacting new voting laws. Now, 10 years after Shelby County, we've seen a torrential downpour of anti-voter laws that disproportionately impact voters of color, from the closure of polling places in Black communities, to racial vote dilution in voting maps, to laws that make it harder for everyday Americans to vote. In her dissenting opinion in Shelby County versus Holder, Justice Ruth Bader Ginsburg said, "Throwing out pre-clearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you're not getting wet." In the absence of legislation to restore the federal VRA, more states are passing their own voting rights acts. These state VRAs protect and expand the freedom to vote and make it easier to challenge discriminatory election laws and voting maps in court. But the freedom to vote should be accessible for every voter, not just ones who live in voter-friendly states. Congress must enact legislation to stop the torrential downpour of anti-voter laws depriving many Americans of their fundamental freedom to vote.